presentation today, and hopefully everyone will learn something. That's the goal anyway, right? And we want to make sure everyone stays out of trouble in the eyes of bar counsel and stays out of trouble in the court system as well. So we will have some hypotheticals at the end, and if there's time, I'm happy to stick around and answer questions and anything like that. But we'll go ahead and get through this, and if you have any questions, hold them for the end, and we'll see what time we have. I wanted to start with just covering some basic common ethical pitfalls. I've been doing legal malpractice and ethics defense since I came out of law school in 2008, and my entire career. So I've had an opportunity to see just about every walk of the practice of law and what problems arise, and they're pretty consistent across different practice areas, the problems that we see, but there are some in particular to estates and trusts, which we'll go over today. If there's one I had to pick the most, it's communication. You would be amazed at how many problems arise from or could have been avoided by communication. When you're talking about communication, we'll go over some specifics later on, but talking about timeliness of communication, your clients need to know that you're there. A lot of times when people end up being sued or turned into grievances, because they just didn't answer the phone or didn't return emails or didn't keep the client up to date as to what was going on. Consistent communication, again, letting your client know that you're there and you're working on their file. Failure to follow instructions, keeping open lines of communication about what the client wants and what's going on and what instructions you've been given, those kinds of things. And then confidentiality, we'll talk a little bit about today as well. Client screening is something that, I'd have to say I see it in most cases that I handle, that a client will look at me and say, I knew this was going to be a problem. I knew this client was going to be a problem. And I didn't do anything about it when I had a chance to do it. So client screening is a big part of the practice of law. It's one of the hardest parts for young lawyers. One, because you don't have experience, and two, trying to make a name for yourself. You tend to take on cases that you might not otherwise, just because you're trying to get ahead and trying to help people. But it's one of the most valuable skills you can learn to screen your clients and decide which are the ones that you should be taking, and sometimes which ones you should be turning down, especially if the client is not cooperating with you. So client screening is a big issue that we encourage people to learn about, to pay attention to, and to trust your gut on. Even if you can't really identify what the problem is, if your gut's telling you, I really need to walk away from this, trust me, you should walk away. No fee is going to be worth putting yourself in the position where you're having a grievance filed against you or having a legal malpractice case filed against you. Conflicts of interest is one we see, often people just not identifying when conflicts exist, or if they do, not getting them waived properly. There's a procedure for it. It's in the rules. You have to do it in a particular way. You have to give certain advice to the client about the conflict of interest, and then you have to get the waiver in writing. If you have a conflict of interest, I suggest, and you think it's waivable and you want to get around it, we're going to go over it today, but I suggest you call somebody that's done a conflict waiver before, or if not, you can call me and hire me and I'll help you. But a conflict waiver, at least a form that you can work from, is important. Diligence is another one. That's pretty simple. We see people procrastinating and then they get themselves into positions where they've created an issue in a case. Pretty straightforward. It happens. Everyone in my office has had the case where the plaintiff's attorney missed a statute of limitations or something like that. That stuff happens. The best thing you can do is to stay ahead of your cases and have a strong case list and make sure you're checking your cases and making sure you're meeting your deadlines so that you don't run into any diligence problems. Probably isn't a huge deal for people on here, but taking cases in new practice areas is an issue. You know, if you don't do bankruptcy law, don't take a bankruptcy case unless you're associated with a bankruptcy lawyer who can tell you about it. In the estates and trust world, you know, if you're taking on a client that has sort of, you know, issues that you haven't dealt with before, you should consult with people in the bar. Call up a colleague, say, have you ever seen this before? Do you have a form I could look at? Those kinds of things. Make sure that you have resources available to teach yourself what you're doing in a new practice area, because oftentimes you can run into problems. Capacity issues, I'm sure you saw from the title, is something we're going to talk about today. It's probably this area of practice is probably the area that sees this issue the most. And I unfortunately will tell you that there's not a lot of developed law on that issue. So we're sort of finding our way through it as a practice and as a bar and across the country. The law is going to be changing, I think, over the next few years as we, you know, not changing, but becoming clearer, I hope, over the next few years as we, you know, sort of work through these rules. But you will see later today, the rule, unfortunately, it's not the clearest. So, common causes of malpractice. Obvious one is substantive errors. Believe it or not, it's probably the least common is substantive errors. It's not that often that somebody, you know, messes up the law or does something wrong, you know, substantively. More often it's, I wasn't paying attention, I made a mistake, it was sloppy, that kind of didn't calendar something right, that kind of thing. But substantive errors do occur: lack of investigation, failing to know the law, lack of experience, especially for the younger attorneys on here, that when you don't have experience in you know, you're involved in a case. If it's adversarial, maybe the other side has more experience than you. That just means you have to work harder, that kind of thing. But knowing the law, taking cases and taking clients in areas of practice where you know the law is critical to avoiding substantive errors. Or if you don't know the law, learn it. Take the time. You know, sometimes you want to take what's known as the lost leader case, where you know you're going to spend way more time than you're actually going to bill for on a case, because you've got to learn the area, but you want to learn this new area. So you will recognize, I'm going to lose some money on this case, but I want to learn this area so I can make money on the next case. And that's important to learn the law so that you don't make substantive errors. Administrative issues, calendaring, missed deadlines, and procrastination. For those of you that use staff for your calendaring, you need to know, and sometimes people need a reminder that you're ultimately responsible for ensuring that your calendar is correct. If you miss a deadline because your secretary didn't calendar right, that's on you. It's not on the secretary. So I do all my own calendaring. I know I'm probably unusual in that regard, but I am very paranoid about missing a court date or missing a deadline and that kind of thing. So I always calendar my own things and calendar out, you know, tickle deadlines, 30 days, 60 days, 90 days, that kind of thing. Even if your case doesn't have deadlines, let's say you're doing a will for somebody who technically does not have a deadline, I suggest you calendar yourself deadlines that would be a reasonable amount of time, because you never know when something might fall off your radar. You get busy with something at home, or you get busy with something at the office, and something might fall off your radar. If you've made a deadline for yourself, even if it's an artificial one, it'll remind you that it's something needs to be done, but it'll make sure you're doing things, you're getting wills, you're getting, you know, trust documents, whatever it is, back to the client in a timely fashion. So I suggest that you know, come up with a system to make sure that you're meeting deadlines and that you get things back timely. And try not to wait till the last minute. Everyone runs into deadlines that, you know, you can't avoid running up against a deadline, but the more time you have, the more with a deadline, the more time you have to fix something if something goes wrong. So procrastination tends to lead to problems because, you know, you end up against the deadline and then it's too late to fix something. So, you know, try to avoid that to the extent you can. And then client relationships is something that I see being undervalued a lot of times, and people, you know, worry about getting the work done and getting the work done correctly, which is important, but also maintaining the relationships with the clients can go a long way to avoiding problems. Even if you make a mistake, it is much easier to rectify the mistake with the client typically if you've got a good relationship, if they believe that you have their best interests at heart, if they believe that if you've been communicating with them regularly, they know you're there, they know you're working hard, they're going to be more likely to forgive a mistake or that kind of thing, or give you an extension to do something if you've got a good relationship with your clients. So listen to your clients, follow their instructions, obtain consent when necessary. Doing those things can go a long way to avoiding problems. We'll start with two of the simpler, easier rules that everyone knows about, I'm sure. Competence and diligence. It basically just requires that you as an attorney, have the knowledge and the skill to provide competent representation. When they send you out into the world, out of law school, you have a license to practice law, you pass the bar, all that stuff. You have the same license as the person that's been practicing for 30 years. You are required to have the same degree of competence as the person, or the same minimum degree of competence as somebody that's been practicing 30 years. So it's important that when you step out there into the world and start taking clients, that you're competent to do what they're asking you to do. If they're asking you to do something that you're not familiar with, it's your responsibility to let the client know, hey, that's not really my area of practice, or I'm going to associate with another lawyer who can provide some guidance here, and I'm going to learn about that. With regard to diligence, it's about being prompt and representing your client. It's about meeting your deadlines. Again, don't procrastinate. One of the things I want to talk to the younger lawyers about that I think also is particularly difficult in this time we're living in right now is to have mentors. And a lot of you have done, obviously well joining the bar and bar associations, and that can be extremely valuable. Meet attorneys around the bar that practice in your practice area. Go to social events when we're allowed to do that again. Come to things like this, because you will discover that most attorneys are more than willing to help, especially younger lawyers who have questions, who want to learn. There are a ton of resources, both formally through bar associations, but also informally through other members of the bar, that you can avail yourself to if you're just willing to reach out. And when you are a solo or a small firm practitioner, you don't have the same resources I have here at my firm, where we have, in any given day, 20 to 30 lawyers in the office. So if I have a weird issue that pops up in one of my cases, I can walk down the hall and say, hey, have you seen this before? What do you think? Here's my plan. What do you think? If you're a solo, you don't have that. So having a network of folks that you can call as a substitute and say, hey, let me run this by you for 10 minutes. That is absolutely invaluable especially when you're first starting out. But even if you have 30 years of experience, you're going to come across an issue that you haven't seen before. It's just inevitable. And so having a network of people you can reach out to is absolutely critical to making sure you're on the right path and you come up with new ideas and that kind of thing. So I'd encourage everyone to avail themselves to mentors, no matter how experienced you are at the bar. With regard to scope of representation, this really what I wanted to talk about is making sure in your retainer agreements you're outlining the scope of representation. The rule states you shall abide by the client's decisions concerning the objectives of the representation, and you have to consult with the client as to the means by which they're to be pursued. So what does that mean? Clients make certain decisions with regard to representations. In the estates and trust world, what does the client decide? Client decides what do they want to happen to their assets. Okay, if you're doing a will or you're doing a trust, what do they want to have happen? Where do they want their money to go? Which of their children do they want to benefit from their estate plan? What do they want to accomplish? That is what the client decides. Your responsibility is crafting the appropriate plan, crafting the appropriate language to implement those instructions. Most lay people that you deal with in the estates and trust world are going to have no idea whether a will is appropriate, whether a trust is appropriate, when a different document is appropriate, what the words even mean. I'm sure all of us have sat in meetings and say, can you explain this to me? Because they can read it, but it doesn't, sometimes people get overwhelmed by the legal language, even if it's clear, and just want it put in layman's terms. So your job is to craft appropriate language to implement clients' instructions, but they ultimately make the decision. So they have to understand what's in the document. So you need to make sure that they understand, whether it means sitting in a meeting with them and reading it front to cover or cover to cover, if that's what they want. That's what you got to do to make sure that they understand and can give their approval, because they can't give approval unless they understand what they're approving. And it's your job to make sure that they do and that the language correctly implements their instructions. How do we define the scope of representation? There is no better time to do that than in your retainer agreement. If you don't use written retainer agreements, start using written retainer agreements. Technically, unless you're doing a contingency case, they're not required in Maryland. I will tell you that the Office of Bar Counsel very much encourages, without requiring, but encourages the use of a written retainer agreement, and you would be silly not to. Because if you don't have a written retainer agreement of some kind, then if there's ever any dispute as to what the terms of your engagement were, how much you were charging, whatever it is, there's no written agreement in place that governs. So, you know, a client could misremember. A client could lie. I wouldn't say a client ever will, but a client could lie about what the terms of the agreement are. Unless you have something in writing that's signed by the client at the outset of the representation or near the outset of the representation, then there's going to be nothing in writing to demonstrate what the deal was. So when you're writing your engagement agreement, it has to be done at or near the time of the representation, that the representation begins. Please, please, please do not do your engagement agreement 9-12 months into a representation, or even worse, change the retainer agreement unilaterally. I just recently, have dealt with issues relating to that. Don't change the deal on the client midway through. Okay. Be specific in your retainer agreement. Okay. Tell the client what you're doing and what you're not doing. Let's say the client wants you to review their will, but likes their trust just the way it is and doesn't want you to look at that. If you're reviewing some, estate and trust documents, but not others, write in your agreement, it's my understanding that you have a will and a trust. You've hired me to modify the will as follows. You have not hired me to look at, and I'm not going to look at your trust document. Okay. So be as specific as you can to outline what you're going to do and what you're not going to do. That way, there's no dispute, or if there's a dispute later on, you can point back, and if it's specific and clear, the better off you'll be. If a client has multiple matters, state which ones are covered and which are not. Moving on to communication, like we talked about at the beginning, communication is what I consider one of the absolute most important parts of a representation. Not only do the rules require a certain level of communication, it goes a long way to avoiding problems with clients. So what do the rules require? One, you have to promptly inform the client of any decision or circumstance with respect to which the client's informed consent is required. What are we talking about? Conflicts of interest, have a limited scope of representation, those types of things where the rules require informed consent. You have to inform the client of those decisions and give them plenty of time to make them. Number two, keep the client reasonably informed as the status of the matter. Okay, don't leave the client hanging for 3, 4, 5, 6 months without checking in, even if it's just to check in and say, hey, we're still waiting on X, Y, and Z. Hey, we're still working on this. If the client knows you're there, knows you're working on it, the less likely they are going to be to complain or create problems for you. You have to promptly comply with reasonable requests for information. This has become incredibly more difficult. Email has been a wonderful tool for the practice of law. It is also at times the bane of our existence, because a client can pick up, open their computer and send you an email any time of the day, Saturday, Sunday, 4 o'clock in the morning, whatever it is, say, what's the answer to this question? And they expect a response within 24 hours usually. You know, I try to encourage people to set some boundaries with regard to email, but it also creates expectations that you need to respond promptly. I generally tell people that, you know, if you can try to respond to people within 24 to 48 hours, to at least let them know that you got the email, or let them know that you got their voicemail, that kind of thing. Even if you can't get to it, just let them know that you've got it and you'll get back to them. If you can't get back to them the next week, just say, I'm jammed up right now. Can I get back to you next week? So just, you know, if they're asking for things, make sure you don't ignore a client request for information. You have to consult with the client about any limitations on your ability to represent the client. That would include conflicts of interest and that type of thing. Subsection B requires all attorneys to explain the matter to the extent reasonably necessary to permit the client to make informed decisions. It is deliberately written that way to be as broad as humanly possible, because who knows what's, you know, obviously reasonable minds could disagree as to what information is reasonably necessary. But you need to have the client, you need to explain to the client enough information to make them understand what the issues are, how the issues are being resolved, and if there's different options for resolving a certain issue, what the pros and cons of each option is. So they need to know enough about the matter to you have to keep the client reasonably informed about the matter so they know what's going on. What are the issues? What are the solutions we're proposing? You need to provide the information to the client timely so that they can make an informed decision. And this one, the last thing on this slide is one of the most important. If you're going to communicate with a client about an important decision in the case, communicate that decision in writing. If a client makes an important decision, they're faced with, you know, a problem where there's solution A and solution B, okay? Have a conversation with the client, but then get on the computer and say, per our conversation, here's what we talked about. Here's what you decided. I'm going to go implement this plan now, okay? That is particularly important if the client is doing something against your advice. If a client ever does something that is against your advice, you should always put it in writing. I have advised you to do X. You have informed me you want to do Y. Doing Y is not unethical, so I'm going to go ahead and do it, but it's against my legal advice. Because if it goes terribly wrong, like you predicted it might, you want that right and say, see, told you this was going to be a problem. And, you know, here we are. You don't want to be in a circumstance where it goes horribly wrong. And then the client says, well, you never told me that. You say, well, yes, I did. And if there's no writing in place, it becomes your word against the client's word. If you end up in my world where we're, you know, explaining the situation to a bar counsel or to a judge. So communicate in writing, very, very important. Some things we see, you know, issues we see with communication, lack of clear and concise retainer agreement, lack of consistent and timely communication. I tell people calendar cases every 30 to 60 days for an update, even if it's just to say, again, we're working on it, we're here, we'll get back to you, that kind of thing. We talked about forms of communication being writing. Keep good phone notes if you have a phone call. It's always okay to follow up a phone call with an email confirming it. Text messages have become increasingly important for attorneys to communicate with clients. It's a very, you know, clients like it because it's easy and it's informal and it's just a common way that people communicate now. I tell attorneys to avoid text messages if possible. I know a lot of people don't want to hear that because they find that tool very, very helpful in keeping up communication with clients. The problem in my world with text messages is if you're communicating with a client about things in text messages that later become important to a defense in a disciplinary case or in a malpractice case, if you don't have the same phone, we might not have access to them anymore. And getting text messages from a wireless carrier is next to impossible in my experience. So if you don't save the text messages to your file, either by printing them or saving them in the cloud or something like that, then the fact that you sent a text message about it, you may not be able to prove it down the road. Okay. So it's a very valuable tool, and I understand that, but it's also a very dangerous tool because people become so reliant on it. And if I had $1 for every time I said, well, that was 3 years ago, I don't have that phone anymore, or my phone deleted, I can't find them on my phone. I know I sent it, but I can't find it on my phone. Well, in your defense, as part of your defense in a grievance matter, text messages might as well not exist if we can't find it. So avoid text messages if possible. If you're going to use text messages, don't use them for important decisions, or if you do, follow up with an email, or make sure you're saving your text messages to the cloud or to your file, printing them, doing something so that they're available to you later on down the line if you need them. We talked about confirming telephone conversations, and if a client is ignoring you or not following your strategy, that's when it becomes particularly important to confirm advice or instructions in writing. Confidentiality, everyone, I'm sure, who went to law school remembers the confidentiality, or at least talking about the confidentiality rule and the requirement to maintain things confidential. So I won't spend a ton of time on it, but you just have to remember, obviously, you can't reveal confidential information unless the client gives informed consent, or you're impliedly authorized to share it. Subsection B talks about the exceptions to the confidentiality rule. Most of them, don't come up all that often, to prevent reasonably certain death or substantial bodily harm, that kind of thing. In my world, the one that's usually most important is to establish a claim or defense on behalf of an attorney in a controversy. So you are allowed to reveal confidential information to the extent it is reasonably necessary to do so. To comply with the laws, to rules, to secure legal advice, those types of things are all exceptions to the confidentiality rule. The attorney-client privilege in estates and trusts, in the estates and trust world, it's important in every context, obviously, but in particular, in certain situations you deal with in estates and trusts, it becomes very, very important. Most lay people don't fully understand or appreciate the privilege unless you explain it to them. So you need to make sure that you do that in cases where, let's say you have an elderly client that comes in for, a will or something like that, and they come in with, their son or their daughter, who brings them in, and then they want their son and their daughter in the meeting because it makes them feel more comfortable. I'm sure everyone that's done estates and trust has had that situation occur. Obviously, very important to explain to the client, who's the elderly person that came in, what the attorney-client privilege is and what the impact of having that individual in the room could be. Okay, so you can't just bring the son or daughter with you back with the client in the initial meeting and start talking about confidential information relating to the estate plan. Okay, you can bring them back, have a meet and greet, and then say, okay, well, I need to talk to mom or dad separately, step outside in the waiting room, and then meet with your client and explain. Here's what the attorney-client privilege is. Everything I tell you is protected. If you bring your son or your daughter in here, an argument could be made that all the information we talk about is no longer privileged and could be discoverable by other people, and that kind of thing. Most people, I'm guessing, aren't going to really care about that, are going to be okay with that, because if not, they wouldn't have brought their son or their daughter with them. But you're still obligated to explain it to them so that they can make an informed decision about whether they want to share that information with their son or their daughter, or whoever it is in the room. So it's important to, kick the other person out so you can have a confidential privilege conversation about the privilege. If they say, okay, no problem, I understand, I still want them in the room, then bring them back in the room and you're good to go. But you have to do it with the client first at the outset of the meeting. I think I skipped one here. Conflicts of interest. We're going to go over hypotheticals later. We're going to cover conflicts of interest, but if you haven't read the conflicts of interest rule, you should. If you haven't read it in a while, you should, and refresh your recollection. But basically, you can't represent a client if there's a conflict of interest, generally speaking, unless one of the exceptions we're going to go over in a minute applies. But a conflict exists if your representation is directly adverse to another client, or there's a significant risk that the representation of one or more clients will be materially limited by the attorney's responsibilities to another client, a former client or third person, or with a personal interest of the attorney. Notwithstanding the conflict of interest, an attorney may represent a client if you have to reasonably believe that you can provide competent and diligent representation to each affected client. The representation is not prohibited by law, and the representation does not involve the assertion of a claim by one client against the other in the same litigation or proceedings before a tribunal. Even if there's a conflict of interest you think can be waived, it needs to be confirmed in writing. The clients have to give informed consent in writing. Rule 19-301.0F defines informed consent generally as an agreement by a person to a proposed course of action or conduct after the attorney has communicated adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct. The most important thing I can convey to you today is informed consent is specific to every case. You cannot send the same conflict waiver to every single client in every single case where you think there's a conflict. And I have seen that happen before, where it's basically, send the client a letter that says, we talked about that there was a potential conflict and you waived the conflict, and so we're good to go, without explaining what the conflict is, how it impacts the representation, what the risks of going forward with the representation in spite of the potential conflict or the actual conflict are, and what reasonably available alternatives exist. I will tell you that if you're writing a conflict waiver that doesn't include advising the client of the right to seek independent counsel, of the fact that if you're representing two or more parties, that there's no, while there's attorney-client privilege applies to the outside world, doesn't apply, between the two clients, you're doing it wrong. Those are things that have to be in the conflict paper. We talk about in this slide. Again, there's no confidentiality between clients, and you have to tell the client that, and you have to tell it to them when you meet with them, and you have to tell it to them in writing. That if you're meeting with a husband and wife to do an estate plan, husband can't tell you one thing and say, keep that, but don't tell my wife. There is no confidentiality between joint clients. It doesn't exist. You have to explain to the clients that if they disagree on strategy and can't come to a resolution of it, that could create a problem that requires your withdrawal. When we're talking about reasonably available alternatives, getting separate counsel involved is one. And again, everything must be in writing. And if you have never done a conflict waiver before and you need to, I suggest you consult with somebody that's very experienced and has done one before, or call me and I will help guide you through it. Common examples, husband and wife, I'm sure is one that everyone on here, or most everyone, has dealt with. Joint representation of husband and wife would create a potential for a conflict of interest. You obviously have to evaluate whether it's a waivable conflict. Do they have common goals and interests? Can their estate plans coexist? If they can't, or if they want different things, or they can't agree, then you can't jointly represent them. You can't put yourself in a position where you can't do what your clients want because they can't agree. Always be wary of, and this happens I see it a lot in family law, but also in estates and trusts, where clients, you're representing clients jointly, and then one will say something like, well, can I tell you this, but don't tell my wife, or don't tell my husband? The answer to that question is no. You can't tell me anything that you asked me to not tell the other person that we're representing, because again, there is no confidentiality among joint clients. So you have to be very careful of that situation arising. Okay, client capacity. This is a rule that's received a lot of attention in the past few years. There is currently a push around the bar to get some clarification. In fact, there's a task force from the MSBA to try to come up with some way to clarify this rule. So we're going to go through it. It's a very difficult rule to deal with because it doesn't really say much. It says a lot, but really not a lot at the same time. So we're going to go through it, and I'm going to give you my best interpretation of it. But I'm also going to tell you that there's a lot out there that is undecided about this rule, so it is a difficult one to navigate. But Rule 19-301.14 states an attorney shall, as far as reasonably possible, maintain a normal attorney-client relationship with the client if the attorney suspects that the client suffers from diminished capacity. So what does this mean? You have to treat the client the same way to the extent possible that you would treat any other client, even if they suffer from diminished capacity. Treat them with courtesy and respect, explaining the matter to them, doing all of those things. If you reasonably believe that a client has diminished capacity and is at risk of substantial physical, financial, or other harm unless action is taken, an attorney may, not is required to, may take reasonably necessary protective action. Sorry for the typo in there. That may include consulting with individuals or entities that have the ability to protect the client, family members, that type of thing. The rule specifically says it may also seek the appointment. You may also seek the appointment of a guardian. I would caution you deeply before going down that course of action, because the rules also state, or the comments also state, that the actions must align with the desires and goals of the client. So what happens when you discover that you believe that the client has diminished capacity and really think they need assistance, maybe could benefit from a guardian of the person or property, or both, but the client doesn't want a guardian, doesn't think they have diminished capacity, puts you in a very difficult position as an attorney who's charged with giving advice to somebody that you believe may have diminished capacity. What I will tell you is, if your client doesn't want a guardian, don't file a guardian petition. Okay, that seems pretty straightforward, but there is a case out there that some of you may have read where client or an attorney did just that, and she ended up being disbarred. Wasn't just for that, but that was certainly a part of what Bar Counsel was very critical of, that she was pursuing a guardianship case against her own client, against that client's wishes. Again, your duty of loyalty is to your client. So if your client doesn't want a guardian and you think they need one, as sad as it is to say, you may just be forced to withdraw and not be able to do anything to help them, even if you want to, because it is not in your best interest to go forth and try to get a client, assistance or guardianship if the client doesn't want it. And that creates difficult positions for a lot of attorneys, but the rules are pretty clear on that. So I have seen a case recently, it didn't go up on appeal or anything like that to my knowledge, where attorneys did successfully seek guardianship over a client. My understanding in that case was that the client didn't object to it. And what they basically did was went to the court and asked for a guardianship, and the court appoint independent counsel for for the client, so that they can have an independent attorney evaluate it. And the court ultimately granted guardianships for the attorneys. And as far as I know, that those are still in place. So it can be done, but it hasn't been done very often. There's not a lot of law on it. So it's an area that you should tread lightly in and tread very carefully. And I suggest you consult with ethics counsel before going down that path if you find it necessary. Subsection C does.
Richard, I don't mean to interrupt you. I just wanted to ask you a quick question. Is
Sure.
this an opinion letter or I guess a time in the moment of representations where representation where an attorney can call your office and say, hey, this is the situation. Can I request an ethical opinion on how to handle this particular case? Is that something that you would do?
Absolutely it is. You know, I will tell you again, there's not much out there on this, even nationwide, there's not. But if you find yourself in a position where you don't know what to do, or you're about to do something like, you know, especially with this rule, if you're about to take action under 1.14, I would suggest that you consult with, you know, multiple attorneys in the area of practice you're in, and you consult with ethics counsel to make sure you're on solid ground. Now, that doesn't mean that, look, if the client comes to you and you suspect they have diminished capacity, but they can understand things with certain assistance, and they say, yeah, you know, my son or my daughter comes with me and helps me with these things, I'd like them to be in the meeting, you know, and you're comfortable that the client can understand what the, you know, what the will says with the assistance of their, you know, the person they brought with them. You don't need to pick up the phone and call me for that. The rules clearly provide that you can, if you think it's necessary under the rule, to consult with individuals and others that can provide protection to the client, and the client doesn't have any issue with it, then I don't have any concerns whatsoever about that, as long as the client, you meet with the client in advance and get their permission to do so. The problem comes when you get resistance from your client. You think that you can't do anything with them because they have diminished capacity. They don't believe that they have diminished capacity. So they're telling you, no, I don't want my son or daughter involved. No, I don't need a guardianship. I don't need these things. I'm totally fine. I can handle my own affairs. And you've met with them and you're saying, no way. That's where the problem comes. And you know, unfortunately, or fortunately, I guess I should say, attorneys have this overwhelming desire to help people, even when, you know, even if it means pushing the envelope on their own, you know, putting themselves potentially at risk. Say, well, I just wanted to help the person. They needed help. And I get that, and I understand that. And that's a wonderful trait that members of our bar, you know, have. But sometimes, you know, you have to look at a situation and say, I would love to be able to help, but at what cost? At what potential cost? Is it worth, you know, being in the crosshairs of bar counsel, being the first case that's been charged, first case in the state of Maryland where 1.14 is charged? Because there hasn't been a published case where bar counsel has charged 1.14. Do you want to be the first one? Probably not. Okay, so there may be a situation where you have to make a difficult decision as to whether you carry on acting for that client or not. So yeah, if you find yourself in a position of trying to invoke this rule, and you know the client is resistant, or there's other sticky issues you identify under the rule, absolutely pick up the phone and call, and I'm happy to talk with you. And attorneys hire me all, you know, I've talked to attorneys on a number of different occasions on this rule and other rules, and so it's certainly something that's within the bailiwick. I don't always look. There are times where I have to look at a client and say, I honestly don't know. I can give you yeah, you could do this or you could do that, but I can't tell you what the Office of Bar Counsel is going to say about this, or the Maryland Court of Appeals is going to say about this, because there's no law on it. And this area, this rule in particular, is one of those rules where there's just not a lot of developed case law on it. And we all do the best we can to interpret it based on what we have available, but there's just not a lot out there. So it's difficult, but we have to do the best we can. But one of the issues that I guess I want to move on to before I get to that, I want to touch on comment one, because I do think it's important, and it usually comes up when we're dealing with this issue. Is comment one specifically states that the law recognizes intermediate degrees of capacity, and what that means is the client could have capacity to do some things and not others. Okay, a client could have the capacity to pay the rent, but not have the capacity to sign a will. They could have the capacity to sign a will, but not, you know, evaluate a complex trust document. Okay, so there's varying degrees of capacity. The difficult part is none of us, well, I shouldn't say none of us, there may be one on this call. I, at least, am not a trained medical doctor, nor am I trained to evaluate people with regard to capacity beyond, reading this rule and what tips and tricks I've learned over the years. Okay. So it's highly unlikely that you are qualified from a medical standpoint to give an opinion on level of capacity. Could you send your client to a doctor and get an opinion on that? Sure, if your client will go. And that's an option that the rules clearly provide is an option. But sometimes even a doctor is going to be able to say, well, it sort of depends on the time of the day or who's around and that kind of thing. You have to make your best judgment when determining whether somebody understands what you are explaining. The good news is there's at least some law out there that suggests that as long as an attorney makes a reasonable determination of capacity, even if that determination ends up being wrong, it's not going to be a basis for either civil or disciplinary liability, because basically we don't want attorneys getting drawn up on charges by bar counsel or something for making a reasonable determination that they thought was the case, and then it turns out maybe that was wrong, because the law does recognize that we're not doctors and that kind of thing, but you do have to make efforts to evaluate capacity. So some tips that I've come up with as I've thought about this issue and talked about it with some of my partners and seen some talked to various practitioners. We talked about at the beginning when explain, or near to the beginning, when explaining the privilege issue, that you need to meet with the client separately from friends and family. If a client comes in with friends or family, and in particular if you're trying to evaluate capacity, meet with the client separately from friends and family. Okay, talk to them, not just about what they wanted in their will. Talk to them about where they grew up. Talk to them about their family. Talk to them about their interests, their hobbies, things that are personal to them, things that they would have to remember from many years ago, things that they may have to remember from a few months ago. Okay, and just ask them questions, have a conversation. One, it's going to help you develop a relationship with your client. That's always a great thing. But two, you can get yourself additional information that may be relevant to the representation, but also information that you can use to evaluate capacity. So you're certainly going to want to ask about the client's goals and that kind of thing, that all the things that are relevant to your representation. Would you ask about, their address, where they grew up, historical details, that kind of thing. Then send the client back out to the waiting room, okay? And have them wait 15 minutes. Maybe you can use that time to take a phone call. Maybe you can use the time to meet with their family if they want you to meet with their family separately. And then have them come back in 15, 20 minutes, okay? Ask them and say, I just want to verify. These are your goals, tell me again what your goals are, right? If the client in 20 minutes can't give you the same story, can't give you the same goals, can't give you the same reasoning behind what they want to do, can't remember what they told you 20 minutes ago, that should be a sign to you that there's a potential problem and that maybe now's not the best time to do this, or maybe you need to do some further investigation on capacity. I'm guessing the majority of the time, client's going to come back and say, well, here are my goals and here's the reason behind it, and it's going to match up perfectly and it's totally fine, and you move on. But if they can't remember what their address is, if they can't remember where they lived, 5 years ago, if they can't remember what their brother's name is, what their sister's name is, what their mother's name, all those types of things, then those are clues that you can use to determine whether a person lacks capacity. Look, there could be a very simple explanation for it, but what you're trying to do is identify the issue. And this is a very helpful way of potentially doing it, because sometimes, when time passes, even if it's 20 minutes, 15 minutes, that may be enough time for someone to forget even why they came to you. And if that's the case, it could be an indicator that they lack capacity. I'm not saying it's the be all end all and it will help you, make a decision, but it may help you identify the issue. So moving on to what happens if, you get during the course of a representation and, you're experiencing dissatisfaction with a client. I'm sure we've all been there from time to time. The first thing you can do is help, do your best to manage client expectations. Okay. And if there's a problem that arises, do your best to repair the relationship. Okay. If the client's not happy about something, trying to identify what they're not happy about and fixing it is obviously going to go a long way to repairing that relationship. But if you get so far down the line that you receive a threat of a lawsuit, or the client tells you, I'm going to sue you, or the client tells you, I think you did something wrong. Okay. It's important for you to understand when you have to report that, or when you should report that to your insurance company. Most insurance policies, and of course I have to talk about this in the abstract because everyone's insurance policy is a little bit different. But generally, malpractice policies are all written pretty similarly. When you get the letter saying you've been sued, or you get a copy of the complaint, isn't necessarily the first time you would be obligated to tell your insurance company about a potential problem. Okay. It's easy when you don't think there's anything wrong, and then you just get a letter in the mail, a demand letter in the mail, or a complaint in the mail saying you've been sued. Say, okay, well, now I know I need to tell my insurance company that I've been sued and turn it in. If a client emails you and said, I'm being assessed these taxes because you screwed up my estate plan, okay, that is enough under a lot of insurance policies to put you on notice that there could be a problem, and that would require you to let your insurance company know, because a lot of the insurance policies have in there that you're required to report a claim when a reasonable person would have had notice that a claim might be made. Okay. And that's critical in in malpractice policies, because malpractice policies are typically claims made and reported policies, which means that you have to report to the insurance company a claim in the same policy period in which the claim is made. And if the client sends you the email saying you screwed this up and then doesn't file the lawsuit until 2 years later, and you don't report it to the insurance company until you've actually been sued, and the insurance company finds out that 2 years earlier the client sent you an email saying that you screwed it up, the insurance company could take the position that a claim was deemed made under the policy 2 years ago, and you were required to report it during the policy period 2 years ago, and you didn't, and therefore you no longer have coverage. That is not a situation you want to find yourself in. Even if it can be litigated with the insurance company, you don't want to be in a position where you're being forced to litigate against your insurance company about a notice issue. So if you have any questions about this, contact somebody that does insurance coverage. If you have any questions, you're also always going to be safer reporting it. The insurance company might tell you, thanks, you didn't need to report that, but I appreciate you letting me know. If anything comes of it, let me know. And that's fine. At least you're not now going to be subject to an argument later on down the line that you didn't timely report it. A lot of people are hesitant to report claims because, it goes on their record and they're afraid their premiums are going to go up. And that's not an illegitimate concern. But the concern of, hey, we might get sued for malpractice, and if I don't tell my carrier on time, you might not have coverage, should also be a big concern. So if you have questions about reporting or anything like that, contact somebody that does insurance coverage work. And there's people in my office that do it. There's other people around the state that do it, and they can help you determine whether it's something you need to be reporting. If you do get into a dispute with a client, don't try to resolve the claim with the client without talking to somebody that's done that before. There are certain rules you have to file, certain notices, certain notices you have to give. Client has the right to seek independent counsel, that kind of stuff, before you resolve a claim with a client. So reach out to somebody. In addition, under insurance law, if you have a malpractice policy, you don't want to be compromising claims without telling the insurance company about it, because they can also deny coverage for that as well. So Just be careful about that. So I've come up with a couple of hypotheticals here to, cover some of the issues, and these are probably going to seem silly to a lot of you, but I find them helpful sometimes to, even if they're not such a real world example, to at least put them in context. So the first hypothetical is Susie Smith brings her neighbor, 91-year-old Richie Rich, to change Richie's will. Susie insists on being in the room for the meeting to discuss Richie's plans because she's the one who looks out for him, and Richie agrees. Richie tells the attorney that he wants to cut his son and daughter out of the will and wants to leave everything to Susie. He can't remember his kids' names, but Susie reminds him of the names when they're in the meeting. Richie's only known Susie for 3 months, but she visits him all the time and she's nice to him. Susie tells the attorney that the son and daughter live in Washington, D.C., but they never come to visit Richie. Richie tells you that he thinks the son and daughter are trying to steal all of his stuff and leave him penniless. Richie said that when his son came by last week, he stole his lawnmower. Someone else has cut Richie's grass for the last 20 years, but Richie thinks he might need the mower next week. When his daughter came by 2 weeks ago, she was taking his car to the mechanic, but he thinks she was trying to steal it. Richie thinks that Susie's looking out for him and just wants his stuff to be safe. The attorney drafts the will just as instructed, and 3 weeks later, Richie comes in to sign the will, but is dropped off by his daughter. In passing, the daughter tells the attorney she didn't know Richie wanted to change the will or why, as he never mentioned it before. Daughter mentions that she or her brother come by and have dinner with Richie every week. However, they've been cleaning out his house to make arrangements for Richie to live with her because they don't think Richie is able to care for himself anymore. Attorney sits down with Richie to sign the will. Richie can't remember the attorney's name. He also can't recall why he's changing his will, but still wants to go forward if that's what Susie wants. Attorney tells Richie not to worry, that he drafted the will exactly how Richie wanted it last time. Attorney flips to the last page for Richie to sign, and Richie writes an X on the signature line. Attorney tells Richie that his paralegal is out to lunch, but she'll notarize everything later this afternoon. Attorney tells Richie he will mail Richie a copy of the will and that he'll keep the original in his paralegal's desk. So, some of the issues, I guess we can do this. Brett, do you want me to open this up at this point and see if people have some ideas, or?
Sure, absolutely.
All right. If anyone wants to jump in.
I think by the facial expressions on everyone's face and the cringing looks as you were reading through that, I think we all kind of know what what to say. But yes, absolutely.
So. We try to make it. We try to make it. But if anyone here thinks that the attorney did the right thing, feel free to try to explain. But does anyone want to jump in and I guess identify some of the issues? Anyone? All right. Well, if no one wants to jump in.
Richard, could you flip back to maybe like the first page just to like refresh the recollection, and maybe like we could point out like on the first, like the beginning of the scenario, the hypothetical.
Yeah. So first, I guess Susie Smith brings her neighbor and Richie to change the will. She insists on being in the room for the meeting. Obviously, the first problem the attorney, first problem is that the attorney doesn't do what we talked about, making sure that you meet with Richie to make sure that, one, he has capacity, and two, that he understands the risks of having Susie in the room and the privilege issue. By failing to do that, you haven't done your due diligence on the capacity issue, but you've also, created a potential waiver of the attorney-client privilege without the client even knowing about it or understanding it. So that's the first issue. Anytime you have somebody that wants to change will to cut out family members, and I'm not talking about, hey, this is changed, but something where someone comes in to cut out the son or daughter in favor of somebody that's not related to them, that should be a big red flag. I'm not saying that people don't do that and aren't justified in doing that, but it's unusual, and it should raise a big red flag with you, and it should indicate to you that you really need to be careful in verifying that this is actually what the client wants to do and that they understand the implications of it. Again, not saying that there's not clients that will want to do that and will be justified in doing so, but it's unusual enough that you should be very, very careful. If someone can't remember the names of their children, again, maybe they've been estranged for 20 years and maybe that makes total sense, but we're talking about things that should be raising red flags when you're meeting with a client and someone can't remember the names of their children or the name of their street, things that, they should know, that should be raising a red flag. When clients are coming in with people that they have known for only a short time, okay, that they want to start moving things around to somebody they've, been dating for, 3 weeks or a month and a half or something like that.
How old is Susie?
I don't think I put that in here, but but those types of short-term relationships and people want to change wills, again, not saying that that's not possible and that somebody can't make that decision, but it's something that should be raising a red flag for you to be extra vigilant and extra.
Yeah, was Susie like 35 in a mini skirt, maybe? Is that?
I've seen it, Tony, I've seen it go the other way too. She's in her 90s and he's like, in his early 30s. So it goes both ways.
Yeah. And you just want to be hypersensitive about those types of things. We go through the rest of the hypothetical where Richie's giving information. Again, some of this stuff, could be true. When you're meeting with the client, you have a hard time of knowing what they're telling you is true and what may not be true. So you've got to, the more information you get, the better. So, if some of these things that Richie is telling the attorney, may not be that crazy. I mean, it's a little unusual that if he says, he thinks his son is trying to steal his lawnmower, but somebody's cut his grass for the last 20 years, but he thinks he might need it next week. Obviously, that's kind of unusual. Again, not totally crazy, but unusual. So you should be, having your antenna up. When Richie comes back with his daughter, that's when, obviously things should have changed with regard to what the attorney did, very, very, very clearly. When the daughter comes in and says, I didn't really know Richie was changing as well. Again, that in and of itself is not that unusual. Or why? Because maybe he didn't want his daughter to know. Maybe he didn't want his son to know, that kind of thing. That's not that, unusual. But when you start to get things like, well, now the daughter's saying that she has dinner with Richie every week, and that's totally different than what Richie says, that he never, or what Susie said, that they never come by to visit him. And now you find out that, well, they've been cleaning out his house because they're trying to move him in with the daughter because they don't really think he can care for himself anymore. Am I saying that you should be believing the daughter at whole cloth over your client? No, I'm not saying that at all. But when you're getting inconsistent stories like this, it should, again, be raising your antenna to say, I need to look into this more. I need to find out what the truth is. Is the daughter, somebody who may be lying to it? Is it Richie who may be confused? Is it Susie who may be confused? What is the problem? Because all you know at this point is you're getting conflicting stories. But nonetheless, in this instance, the attorney sat down with Richie and said, oh, don't worry about it. I know you still want to go forward. And, Richie can't remember what was in the will, but attorney says, don't worry. I took care of it. I got it exactly how you want it. Just sign here. Okay. Obviously, you can't go forward with a will when the client can't remember what was in it. That should have been, that one was obviously easy. But also I want to use this time to go over that you really need to sit down and I think sometimes we all get busy and we all think our clients maybe know more than we do, but sitting down with the client to make sure that they understand paragraph by paragraph what's in that will and what it all means. Even if that means just sitting down and going through every single paragraph and say, okay, this is what this means, this is what this means, this is what this means. If that's what it takes, that's what the client wants. We are a service industry. That is what the client gets. Okay. It's important that the client understand the decisions that they're making, why they're making, what it all means. Because if they don't, then they're more likely to complain, or they're more likely to make a mistake, or you're going to make a mistake. And it always brings me back to the example of I know a good friend of mine who's a real estate attorney, and he once sat through a real estate closing. And for any of you that ever bought a house or done a mortgage or anything like that, you know how many pieces of paper you have to sign. And he once sat through a real estate closing where the client read every single piece of paper in the closing from start to finish. He said it took literally all day for them to sit there and read it all. But that's what he was required to do, because that's what the client is entitled to do. Hopefully you don't find yourself in a position where you're literally having to explain every single word on every single piece of paper, but it is important that you take the time and you set aside the time to ensure that the client understands everything. As far as signing the document with an X, I actually put that in there because that happened to me once. And I got into a big dispute with another attorney about whether an X on a signature line is sufficient for a signature. I will tell you that if its client just signs with an X, it may be, I suppose, an indication that there could be a capacity problem, but it's not necessarily in and of itself an indication of that. That's what I was arguing. Maybe the client has, an injury to their wrist and they can't form their name, but they sign with an X. Doesn't mean they can't necessarily understand what was on the pages. It just means that that's the way they sign their name. I'm sure all of us have seen pleadings that have been signed by lawyers with a squiggly line. Doesn't mean that the lawyer is incompetent. It just means that they don't care to write out the letters of their name. But I will tell you that if a client can't sign their name, it could be something that, in combination with other things could raise a red flag. As far as the paralegal stuff goes, that's, I assume everyone picked up on that immediately. You can't, there's been plenty of cases over the last 20 years about this. You can't notarize something unless the notary actually witnesses the signature. So you can't have the paralegal come back later and notarize things when they didn't actually see the client sign the document. It is not good enough for you to say, but I was there and I saw the client, so you can notarize it. That is not good enough. And then as far as keeping original wills in a paralegal's desk, don't do that. I would suggest to you that, you shouldn't be keeping original wills and trust documents for your clients if you can avoid it, because it just creates problems. Because if you're going to keep original estate and trust documents, the rules say you have to keep them in perpetuity forever. And that's not really a situation you want to set yourself up for, nor is it, a situation where if, God forbid something happens to you and then someone has to go in and figure out what happens to all your files and that kind of thing. They have to figure out which ones have original estate trust documents in them, which ones don't. It's just a complete nightmare. So I would encourage you all to ensure that originals get back to the clients for their own safekeeping. You should always keep copies. In today's world of digital, scanning and that kind of thing, encourage everyone to keep secure online records. It's just a lot easier nowadays to just scan that stuff in and maintain electronic copies and that kind of thing. So, but, do take care if you are going to be in possession of original documents. Don't just stick them in a drawer. Don't just stick them in a file. They should be under lock and key, that kind of thing, because you got to keep them secure. All right. We have time for one more, Britt. I don't know how we're doing on time.
I think we've gone over about 20 minutes.
Okay. I can.
It's up to everyone else if anyone wants to stick around and ask questions. I've been actually getting, Richard, several requests for copies of your presentation. I don't know if would you like them to reach directly out to you?
Yeah,
And
I
you
mean,
can send it?
I will talk to some of my partners and just make sure we don't have any issue with
Sure.
circulating it. I don't think it would be a problem, but I do want to talk to a couple of my partners about that. But you can, what I'll probably do is either they can reach out to me directly, or what I can do is talk to my people and then get back in touch with you, and you can maybe circulate it if you have a list of everyone, or
That'd be great.
are.
That'd
So
be great, Chris.
since we've gone over, the last hypothetical wasn't, too in depth anyway, so we can probably skip it for now since I've gone over. But I'd rather, if anyone has any questions, give somebody an
Yeah,
opportunity to
if
ask it.
anybody has any questions, I'll open it up for questions. I completely understand if anyone needs to sign off, but Richard, if you're okay with sticking around for some
Yeah, I'll
questions.
stick around.
Okay,
No problem.
great. So you can either just unmute yourself, or you can type your question in the chat, and I'd be happy to read it to Richard.
I can unshare here. That way I can see the comments. Oh, now I get to see everybody. All right. There we go. Let me see if I can find.
So Richard, you represent attorneys when they get a grievance. I'm just going to ask that question, and,
Yep.
and that's part of, okay.
Yeah, so what I tell people about that is, it used to be, I don't know what the statistic is now, but it once was the statistic that every attorney in the state of Maryland, on average, would get turned into grievance or sued for malpractice once every 7 years, on average. I think that's probably less now. I don't know the answer to that. I hope it's less for the bar's sake. But, chances are during your career, you are going to get a letter from the Office of Bar Counsel. There's more people, I would say, during their career are going to get one than don't. A lot of them, the vast majority of them get dismissed and nothing ever comes of them. And there are many attorneys, I'm sure, that were on today's call that are more than capable of responding on their own behalf and will do so and have no issue. But I would tell everyone that, I could probably find a form and draft my own will too. It doesn't mean I should.
Right.
Just because you could respond doesn't mean you should respond to Bar Counsel. And what most people don't know, and it always surprises me how many people don't know this, is if you carry legal malpractice insurance, you most likely have coverage for grievance defense that is no deductible coverage. You do not have to pay anything to get the coverage. It's just supplementary payment under your policy. Some carriers offer more coverage than others. It's usually limited, but there is at least some coverage under most policies. So if you get one, you probably have coverage under your malpractice policy to turn it in and say, I would like coverage and I'd like an attorney, to help me. And your carrier will call me or somebody else who does it and assign it to us, and we'll help you. We'll meet with you. We'll, get the lay of the land, get the facts, and help you formulate a response, whether that means you take the first shot at drafting it and I just sort of guide you through it, or I do it entirely based on the facts of the case and that kind of thing. And what I will tell you is there have been many instances in my career where if I had gotten a hold of the client before the first letter was sent, I am fairly confident we could have gotten it dismissed. But because the attorney decided to respond on their own, they brought up a whole host of issues that weren't even relevant to the initial complaint that created issues where none otherwise would have existed. The system is a complaint-driven system, but Bar Counsel can ask about anything, anytime, about anything. And so if you, answer the complaint and attach a copy of your retainer agreement when it wasn't even requested, nor was it relevant to the issues. And then there's a problem with your retainer agreement. Bar counsel can now expand the scope of their investigation to your retainer agreement. So I always tell people one of the goals, is to of responding to any grievance is to keep the scope of the investigation as limited as possible. Keep the scope within the scope of the original complaint if you can. Why have bar counsel investigating your attorney trust account if that's not part of the original complaint, that kind of thing. So it's things like that unless you do this type of work on a regular basis, it's not going to be second nature to you, and you could run yourself into potential problems. So I always tell people, again, I would hire an estates and trust lawyer to do my will. If I was suing somebody for, medical malpractice, I'd hire a medical malpractice lawyer. Even though I have a licensed practice law, I certainly could do it, but it's just not a good idea. Same thing with grievance defense. It is very difficult to be objective sometimes about something like that, and so it's very helpful to have an independent voice who can help you, especially one that has been through the process, can explain it to you, can explain to you how it all works and that kind of thing. Plus, I'm sure if you had got Miss Wallace on the line, she would tell you that generally speaking, she much prefers to deal with people who are represented. It always stuns me how many people say, but I don't want bar counsel to think I've done something wrong. And if I hire an attorney, it looks like I've done something wrong. No, it doesn't. It just makes you look like somebody who wants competent legal advice. That's what it makes you look like. So, don't hesitate to reach out if you end up in that situation.
That's great that you have an interest in it. And you actually are there to help attorneys, get
Yeah,
themselves out of trouble and keep them out of trouble. I think that's wonderful.
Yeah,
Does anyone else have any questions? Okay. Well, thank you so much, Richard, for dedicating this evening to our group. Absolutely. And I will send out whatever Richard provides me to